Miami at Faina in Miami Beach. And also we're gonna have the NFTs that Erica is gonna go over specifically. So check them out. These are all scannable. And last but not least, yes, if you live outside of Miami-Dade County and you park in the garage, please let me know. I can validate your ticket.
Maria is the best.
One last this, guys. If you're gonna drink and you're gonna come to Lost Boy after this event, please come to one of us and we'll give you one of these wristbands. They'll give you a 50% off at the bar, okay? Now, Erica, the CEO of the Bitcoin Center, is gonna give you an overview of the NFT process.
Hello. Okay, so you guys, I love seeing a lot of new faces. I love seeing the progression. You guys, last time we... I guess we still don't have microphones. But welcome to Crypto Mondays Law Edition. I have a couple of things that I want to tell you. Welcome to the newcomers. Raise your hand if it's your first time here. Nice, welcome. So we are the Blockchain Center. Essentially what we are is an education hub as well as a co-working office and event space. So if you're interested in co-working, we're actually free for the summer for blockchain companies, and we intend to make Miami the best educated city in the world when it comes to this technology. Hey, Nick, can we turn my echo down or something? Great. Okay, oh, that works better. So, first things first, how many of you guys know about NFTs? Okay, how many of you heard about crypto kitties? Okay, so these are non-fungible tokens that as a Crypto Monday member you get to receive. They have certain values attached to them. I have 10 NFTs that I'm giving out that will give you 15 minutes of free office hours with Drew Hinkes right here, and Drew's going to be talking today. And another thing Maria told you about is this upcoming party. Now, I know I do a quick Bitcoin 101, and can I have the clicker? Thank you. I'm just going to do it really quick this time because we've got a lot of lawyers in the room. Why is that funny? Okay, so this is the law edition, right? So first things first, I have Stephen Miner from the SEC, but he's not here for the SEC, you guys. He's running for Miami Beach Commissioner. He's going to talk after me. And then I have these two gentlemen right here, Drew Hinkes and Gabriel Shapiro, that will be giving you a regulatory update. So Bitcoin, the blockchain, and you. First things first, an overview. We'll talk about Bitcoin briefly, blockchain, the benefits of the tech, and then a news update. So, how many of you seen this before? And can we relate it to this? If you look right here, this right here is the same as here. Cryptographers tend to do this thing where they mask. This is the Genesis block of the Bitcoin blockchain, where they are indicating that this was written the same day that this happened. So we kind of have to understand that Bitcoin was born first. Now, one thing that I want everybody to know, the words Bitcoin, cryptocurrency, and blockchain are not synonymous. They are not the same thing. They mean different things. Bitcoin was born out of this need for a better form of money. It was posted as open source technology. Open source technology, who needs an explanation of what open source is? Everyone knows? Okay, there we go with that. Open source technology means it was posted in a public place for all software developers to be able to read. So software developers from all around the world saw this Bitcoin source code posted in a public place. They said, wow, this is revolutionary technology. How can we take it and use it for our own use cases? They did that, and they modified it, and they called it blockchain. So Bitcoin source code modified for business use cases. And some more stuff. I'm gonna go really quickly. Evolution of payments, I know you guys have seen my presentation. Money moves, okay? This is over time, and money has changed the way that we spend it. And Bitcoin and cryptocurrencies are just kind of this next step in evolution. Technology continually advances, and we can see what's gonna happen in times to come. I'm not gonna explain this today. And this one, what country is this? Venezuela, Venezuelan bolivars. In 2001, this was worth $71,000. If you've seen this before, don't guess. How much do you think this is worth in 2018? $21. Hyperinflation, guys. No government is immune from hyperinflation, and I want everybody to understand that Bitcoin provides an option, okay? So when you have a national currency that maybe is more volatile than Bitcoin, Bitcoin's a good option for you. And it's more stuff, very cool. Oh look, this is actually pretty cool. Bitcoin has outperformed every single major asset class in 2017, 18, 19. But it's a blockchain, smart contracts, aircraft leasing has got some really cool use cases for crypto. And this is the internet stack. There are 7 layers to the internet, to what we see now today. This is kind of how technology works. There's layers upon layers upon layers for us to see what we have. And you're going to see some stuff happen like this with blockchain. And we only have 1 layer right now that's really usable. So technology is continuing to grow. In the news, here's some cool stuff. By the way, who knows who has the most patents on blockchain technology? It's Bank of America, MasterCard, Fidelity, Goldman Sachs. Like, these are the companies that have the most patents on blockchain. Couple cool things, it's really becoming mainstream culture. Trump is tweeting about it. We have Fidelity offering cryptocurrency trading, join the likes of Robinhood. JP Morgan has their own coin. Lots of cool stuff. Miami, you guys, I don't need to explain it to you. Miami's the best. And welcome to the blockchain/Bitcoin Center. So that was a really quick Bitcoin 101. Now, Steve, I want you to come up. So Steve is a good friend of mine. I used to work, how many of you guys know that the SEC works in one of the buildings on Brickell, right? So I used to work in that building when I used to work in aircraft leasing, and Steve became my friend. And he is not here for the SEC, not representative of them. However, he is running for Miami Beach Commissioner. So he's got some cool benefits that he wants to provide for tech companies. So we definitely want to give him some of your time.
Thank you, Erica. It's great to be here. I'll tell you, just even a few conversations I had, it's really cutting edge to hear some of the projects people are working on and developing. So it's really an honor to be here. I am an attorney with the SEC. I do investigations, fraud generally, committed in the securities markets. Again, I'm not here in that capacity. That would require some approval process, which I could get, but wasn't necessary, so I didn't do it. I'm really here more to talk about issues, and I also happen to be running for commissioner of Miami Beach, which basically it's a body, just to tell you quickly, it's a body of 7 people, elected officials, the mayor and 6 commissioners who vote, and ultimately have responsibility for the budget in Miami Beach, for zoning, fire, police, basically every major decision that's made in Miami Beach. That's what the commission of Miami Beach does. So November, I am running in that position. I also wanted to give a shout out to Erica. I do know her for a couple of years. She's an incredibly talented person. This is no surprise to me to see this type of workplace that she's put together, and I know she's going to even be more successful going forward in the future. So I was going to just talk about a little bit about some of my thoughts on technology and how Miami Beach, but it really, what I'm going to say, it really doesn't even apply necessarily to Miami Beach, but how municipalities can really try to attract and retain good talent and in the technology industry. So the first thing people often think about when they're talking about how to retain good businesses in technology or any businesses, tax incentives. The city should offer tax incentives, which I'm a big believer in, I'm a big fan. That being said, it's a balance. So probably most of you are familiar with what happened with Amazon in New York City, where Amazon was going to spend about $2.5 billion. They were going to bring in 25,000 jobs. Looked great, everyone was excited except Manhattan, the city, New York City, was going to offer $3 billion in incentives. which probably wasn't as bad because it actually was graduating tax incentives depending on how much money Amazon brought in. But it created a lot of backlash, and ultimately the project got nixed. Literally, Amazon one day, without telling anybody, without telling any government officials, nobody knew about it, Amazon pulled the plug and walked away. So there is a balance that has to be done between offering tax incentives and having the backlash that some residents may have. And that's generally true of any issue that a government would have. And in talking in any regulations, somebody asked me today about regulations and how I feel about that. And again, it's a balance. You need a certain amount of regulations in our government to keep things honest, but too much also stifles creativity and entrepreneurship. So another case actually in Wisconsin, the company Foxconn actually had promised to bring in, I don't know how many jobs, but a lot of jobs, and ultimately didn't, and it became a fiasco, and my understanding is some politicians didn't win their elections because of that. So what can we do? What can we do to sort of create that environment for businesses and tech companies in particular? And actually, New York City is undergoing sort of a renaissance in this area. Silicon Valley obviously is the prominent technology, but New York City is making a big push right now. So, for example, Google has taken over 1 million square feet of space in Manhattan, Facebook has, and all others, Microsoft, Lyft, Salesforce, Netflix, are moving into Manhattan. So why? What is obviously Manhattan? Yeah.
Can you get the microphone closer to you because there's a lot of feedback, it's hard to hear.
Oh, okay, thank you. Eat it. Okay. Thank you. I appreciate it. So what is it about New York City that is attracting the talent? And this may be it's New York City, but what about it can we replicate maybe closer to home here in Miami? And I guess from my perspective, I think of how can we bring that to Miami Beach and try to retain and attract good talent. So one of the things New York City has is the brain drain. There's a lot of talented people in a lot of different industries, so automatically companies can come into New York City and grab that talent. And ultimately, in technology, they will take people from the financial industry, which is New York City is the world's hub. So, but there's other issues as well. New York City has a great transportation infrastructure, so it makes it easy for people to get around. Not always so easy in Miami, so that's an issue from my perspective as someone who's trying to hold elected office. When you realize sort of the big picture, how do you keep people and keep good talent and keep people here? Transportation is a biggie. Education is another one. If you offer good educational facilities, and I'm not just talking about at the higher level, graduate and college level. I'm even talking about at the lower level, public schools to bring good families in and sort of raise people, and hopefully they'll continue and stay in Miami. Obviously, New York City is a cultural hub, but we have that here in Miami. I think our government has done a very good job, not just government, but partnering with private institutions and private cultural institutions to make it a cultural hub. So Miami Beach, I don't want to focus too much on Miami Beach because I think there's only a few people here who live in Miami Beach, but it did get rated as one of the top 10 STEM cities for workers, science, technology, engineering, and medicine last year, which is great. But when you break down the numbers, it's really, if anybody who knows Miami Beach pretty well, there's a lot of doctors. So really it comes down to the medical industry driving that. Not so much the technology industry, and I think that's something we really should make an effort to try to push. I have never actually had any conversations with anyone specifically who's working on this. There might be. I don't want to say I'm not an elected official yet, but I think it's something that's certainly on my radar, and I would think that it's something that should be on a lot of different people's radar. And I'll just finish off. There are certain municipalities that are known, and if you're opening a business, that are known to be very business friendly and making things easy, the application process, the tax process. Miami Beach is not known for being easy on that, and it's a detriment because obviously it's a great place to do business, and a lot of people do business there. But I think it's also driving away a certain amount of people. Actually, a writer for someone who has her own blog actually described her own experience, how difficult it was to get a business license in Miami Beach, and that is not good. That word gets out, people are not going to come, and they're going to go somewhere else. So that's a process they're working on, but obviously from your perspective, if you're looking to do business, you want to make it as easy and as simple as possible. You do not want to be spending your time dealing with some government and trying to get a license. Thank you for having me. I appreciate it. Erica's amazing, and it's been a pleasure talking.
So you guys can bombard him with questions later, but just remember, he's not here officially representing the SEC, okay?
I think they got that.
Okay, so next up we have the stars of the show. I have Drew Hinkes. Please stand, Drew. And Gabriel Shapiro. Please have a seat, guys. So what we are going to be talking about, so these are two of my favorite lawyers in this space, and can you take the cap off? We're going to be just giving a regulatory update on what's happening in crypto. We're going to talk about some laws and some cases that have already been evaluated. And then I'm going to ask them a question that I hope everyone is interested in. Just to gauge the audience beforehand, how many people here are attorneys? Nice. Well, this presentation was made for you. So can we hit the last lights in the back, guys?
All right, well, thanks everyone for coming today. I'm going to start with about 5 minutes of overview for those of you who may not be attorneys, since this is not a basics, not a 101 type of talk. We're talking about sort of current events and some of the more advanced topics. So let's start with the very beginning. We have Bitcoin, and then we have a whole bunch of other instruments. We have technology derived from Bitcoin called blockchain, and then we have this explosion in 2016 of people being able to issue their own tokens, and they start selling them into the market in what we call ICOs. And since then, there's been tremendous amounts of value created. Many fortunes have been won and lost by folks following the prices of these assets up and down. But a really interesting thing happened along the way. Traditional finance has also embraced this. And so now we see a world where these assets are sometimes over-regulated, sometimes under-regulated, and sometimes not regulated at all. Depending on where you live, an asset might be regulated in one way and differently if you lived on the other side of an ocean, let's say. So what we're going to talk about here is primarily three topics. We're going to talk about the law of selling tokens in the United States, specifically what our friend who's not here in his official capacity with the SEC, what the folks in his office are concerned with. We're going to talk a little bit about some recent updates with respect to federal taxation of these assets, and we're going to talk about the way the Department of Justice looks at these assets to the extent that they are a medium that substitutes for money. Now, since 2015 or so, folks have been selling tokens they generated in order to raise money. In 2017, the SEC came out with a Rule 21 report that said, if you sell tokens, sometimes they're going to be considered securities, and then the sale and transaction of these assets all have to comply with the standard law that applies to all other securities. I'm super overgeneralizing, but this is the general gist. In 2014, the IRS came out with guidance that said, we view these assets as property, and so you are subject to gains and losses when you sell them, and a whole host of other detail, but they're viewed as property. And then finally, FinCEN in 2013, Financial Crimes Enforcement Network, they are the branch of the Department of Treasury that's responsible for regulating funds to make sure they're not used for things that we think are undesirable, like payment for terrorism or money laundering or financing the war on terror with drugs and all the rest. So they came out with guidance that said if you're doing certain things, then you're required to be registered with FinCEN as a money services business, and you're required to put into place practices and procedures within your business that it provides anti-money laundering, that identifies customers, and that shares a whole bunch of information with the government about certain transactions. And so it's with this very, very general, broad framework that I now pass the microphone over to Gabriel, who's going to start talking about a couple of the more recent enforcement actions.
Hello. So, I'm going to stand. Okay, cool. I'm just going to talk. Okay, cool. All right, so, yes. So I'm Gabriel Shapiro, by the way. Round of applause for Drew Hinkes' socks. Oh, this is not working. Turn on. There. Okay, so yeah, so obviously, pretty much everyone here familiar with the ICO phenomenon, particularly in 2017. Show of hands if you don't know what an ICO is. You don't know, okay. So ICOs were sales of blockchain tokens. Basically, the way the Bitcoin network was launched, basically everyone had to work for their money, so to speak, online, and they received Bitcoin for performing network services. But sort of 2015 through 2017-ish, a different model emerged where people sort of pre-produce many protocol tokens and then sell them to the public as a form of financing to pay the developers to build the technology. And as I describe that to you, that may sound familiar, may sound much like any startup doing capital raising. And therein really lies the issue, is that the sales of these tokens became methods of financing for projects. And gosh, that sounds a whole lot like doing an IPO or a stock sale or another form of securities fundraising. And so this caught the SEC's attention, right? And so in 2017, the SEC published a report about a smart contract called DAO. I won't get into that, but that was the first time, that was July 2017, that was the first time they said some of these tokens may be securities. Shortly after that, a company called Kick, a Canadian company in fact, decided to do one of these token sales anyway. They did not treat the tokens as securities, but they sold a huge amount of these tokens, $100 million worth of tokens. And who bought these tokens? Well, it was a mix of people. Some of them bought the tokens pursuant to an agreement called a SAF, a simple agreement for future tokens, which was modeled on a traditional Silicon Valley investment vehicle called a SAFE. And some of those were hedge funds, venture capital investors, these sorts of things. But then the issue lies in the fact that after that, Kick sold these same tokens called King to the general public. So you take the hedge funds and you take the mom and pops, the general public who bought the tokens, in the wild, and that's $100 million. Now, $100 million, that's huge. The way that Kick would style this is they would say it's like a Kickstarter, right? They're pre-selling a product to the potential fans or users of the product. But do you guys know of any Kickstarters that have raised $100 million? It's pretty unusual, right? So this is the issue, is why are people really buying these tokens? Many people saw the astronomical price rise in Bitcoin, many people saw the astronomical price rise in Ether, and while that may have been surprising to the initial purchasers of those things, now people know that they can make a lot of money for these things, and people are therefore buying them for investment purposes. That implicates the securities laws. So flash forward to this specific litigation. Kick has been being investigated by the SEC most likely for quite some time, probably has been going through a subpoena process for, probably most of 2018, I would guess. Following its investigation in November, the SEC staff advised Kick and its lawyers at Cooley and Kirkland that it would be seeking enforcement. Kick filed a response to that, denying the SEC's allegations that Kick had sold KIN as unregistered securities. The KIN Foundation sort of then launches a big public relations campaign saying defend crypto against the SEC, takes a bunch of donations. Sure enough, the SEC files a complaint against Kick in federal court seeking a jury trial and saying that indeed the sale of KIN, they were securities and it was illegal and the securities need to be registered. And Kick has since filed an answer, so we'll talk about these things. So what was KIN? So KIN was styled as a product, essentially an in-app currency, right? Whereby you could go to Kick's Messenger app and you could spend your KIN to receive stickers or to get discounts on things or to do certain promotions. etc. So the message at least was that this was a product. And what types of things did it buy? Just to fast forward a little bit here, it could buy you one of these stickers in the app that says "Let's Jam." I don't know about you, but personally, I probably would not spend like $100,000 or $500,000 to get these stickers, which some people were likely doing this out. The other purpose for the kin longer term was supposed to kickstart an ecosystem whereby app developers would receive rewards in the token, and the idea was that it would grow in value over time. So the core issue of the case really is, are these kin securities? So under US federal securities laws, there's a long definition under the 33 Act of what constitutes a security. There are very specific things listed, such as stock, such as certain types of bonds, etc. One of the things that's listed in that definition is an investment contract. And what an investment contract is, there's a test for it called the Howey test under federal law, and that says that if there is an investment of money in a common enterprise with an expectation of profits, predominantly from the efforts of others, then that is a security and needs to be treated as such under law. So the SEC is trying to prove that the facts here fit that test. The SEC has focused on Hinkes' public statements at the time, comparing the ICO trend to the 90s .com boom and implicitly promising returns, and that's the bulk of their evidence as to why it's securities. Hinkes has responded. Hinkes' defense are primarily two things. Number one, kin are a currency, and currencies are not supposed to be securities. There's a bit of a technicality here in that under the 33 Act's definition of security, there are no real exclusions as such, but under the Exchange Act actually specifically says that currencies should not be included in the definition of security. So one of the arguments raised by Hinkes is that if it's a currency, by definition, it can't be a security. Ultimately, they need to argue under the 33 Act, and the 33 Act doesn't have that exclusion, but we'll see how that plays out. The other more interesting argument that they've made is that the term investment contract is unconstitutionally vague. And in some fairness, that test is hard to apply, and you ask Drew and me about probably 20 different test cases, and we probably come out different ways on all the different ones. And probably even our SEC friend in the audience would come out differently on some of them than his SEC colleagues. So yeah, it is a difficult test to apply. It's facts and circumstances, but I don't know that makes it unconstitutionally vague. Overall, we're going to talk a lot about the themes here, so I won't dwell on this. But overall, the things to take away from this is sort of the SEC's first court battle over this. This is a must-win for them in their eyes, I'm sure, and it's going to be precedent-setting, assuming that it doesn't kind of settle before it culminates in a court opinion. And but nevertheless, this is the first of many to come. Federal securities laws are very nuanced, are very facts and circumstances based, so these issues are going to play out in courts for a long time to come.
I'm going to continue and discuss another case that came around recently. This is the Simply Vital action. Unlike Kick and Kin, this was not actually litigated. This was a settlement in the form of a stipulated cease and desist order entered into by Simply Vital and the SEC. A little bit about the case. Simply Vital was developing a product called Health Nexus. This is supposed to be a blockchain that's going to hold healthcare-related information. And of course, it has an instrument called the Health Cash, or HLTH, which is supposed to be a payment instrument. They decided that they're going to sell them, just like was described in Kick, in the form of a SAFT instrument. The SAFT instrument was not going to be registered. It was going to be offered as a Regulation D exempted security. We call them private placements. Essentially, this is a way that you can offer securities in compliance with US law without registering it, provided that you do the things you're required to do in order to qualify for the exemption. And so they offered and they sold these SAFT instruments. And they said initially they were going to sell it for over a certain period of time. Came to pass they didn't sell out all their SAFTs, so they continued to sell them. Turns out, at least according to the stimulated order, they knew that folks were putting together pools of potential buyers, meaning somebody says, I'm going to buy this instrument, buy this SAFT, but they were standing in the place of a whole bunch of other people. And as it came to pass, the folks at Simply Vital were not doing the things they were required to do in order to pre-accredit and to AML and KYC their buyers. They sold into pools understanding that they were really selling to a group of people, but they didn't collect all the information about them to determine whether they're the appropriate people to buy these assets under Regulation D. And so in 2018, the SEC called them and said, we see that you're about to sell your tokens to the retail markets. We'd really like it if you didn't do that. And the Simply Vital folks said, you know what, we're not going to do that. We're going to not sell these. And through some negotiation, they decided to return all the assets they had received back to the purchasers of the SAFTs. Several months later, they decided they're not going to generate the tokens at all. So what's interesting about this one? Well, they were charged with violations of 5A and 5C of the 33 Act, which is selling and offering unregistered securities. Now, a SAFT offered under Reg D itself isn't a violation. You can sell a SAFT if it converts into something that's unquestionably a security, and if you comply with the registration exemption, you should probably be okay. The SEC took umbrage with the fact that the thing that was being sold did not appear to be a security if it was actually sold. So even the compliant SAFT offering was tainted by the fact that it was supposed to convert into something that they considered to be a non-compliant asset because it was neither registered nor subject to an offering exemption. And this is the same position they've taken in the KIC enforcement action or litigation that Gabriel mentioned, which is sort of new for the industry. However, here, this is the easiest going the SEC has been on any company. Literally, they were to cease and desist from offering non-compliant securities into the market. No fine, no penalties, no bars from the market. It's probably because they returned all of the money and they never actually got to offer tokens to retail. Hard to tell, but reading through tea leaves, that's what we're looking at. Here's another one that's a little bit more aggressive. This is a case called Veritasium, or Veritasium, I'm not really sure. A little bit of background on this one. There's a gentleman named Reginald Middleton that's been very active in the space since 2013. He offered this product called a Veri token, and he raised a little shy of 15 million. It was not registered or offered pursuant to any regulatory registration exemption. And it was really hard in retrospect to kind of pin back what exactly Veri was supposed to do. At various times it was a prepayment for research. Various times it was supposed to be a software license. It was supposed to be swaps, like financial swaps on Ethereum. And at one point it was supposed to be a DAO, or a decentralized autonomous organization. Well, at any rate, he made a bunch of representations to buyers, which the SEC in its complaint alleges are problematic. He told folks at the time of the token sale that they had products ready to go to market that would replace brokers and banks and hedge funds. They touted returns for the purchase of the token, which is essentially a no-no if you want to not be a security. They had fictional deals with folks that were going to be big global deals. They touted that Veri was going to be used by an expanding airline, a medical marijuana startup, an electric motorcycle startup, and a sovereign nation. At one point, to explain their pivot from software to tokens, they said it was because of regulatory concerns, which is ironic because it's probably easier to sell tokenized software licenses than it is these sort of nondescript, moving target types of instruments. At one point, they claimed they had access to $1.635 quadrillion. Show of hands, do you think that much money exists right now anywhere? It's a big number, I don't know. But one of the really interesting things, one of the new allegations we see here, is that Mr. Middleton himself actively traded up the value of the asset and then publicized it to folks in order to re-emphasize the value in investing this. And so a couple other things that really happened here that were interesting. There was allegedly one large investor that put in $1 million. It's alleged that Mr. Middleton took $450,000 of that for himself, and took $100,000 to make a political contribution, and then repaid that investor with funds from the original raise. You can probably see this one's a little bit different than Kick and Kin, where it's a question of whether something offered needed to be registered or not. This one's got a little more allegations of fraud involved. The latest thing when the SEC decided to enforce is that they were going to use the offering proceeds to buy precious metals to back a new token called V-Gold. So the SEC told Mr. Middleton, who was primarily in control of this offering, that they were going to bring an action and they wanted him to not move any money around. Apparently he decided to liquidate $2 million of offering proceeds, and so the SEC said, okay, we're going to try to go get an injunction and a freeze order against you, which is something new. They also sought an independent intermediary over the assets, which is also new. But going back to Mr. Middleton's alleged manipulation of the price, this is the first time we've seen an IA2 claim brought under the 34 Act against an issuer for purportedly manipulating the price. So that's something interesting to keep an eye on. And wouldn't you know it, the temporary restraining order was granted. How about that? So what that means is until the 22nd, so for about a week, Mr. Middleton and the various stadium folks aren't supposed to do anything. They're not supposed to move any money, they're not supposed to spend any money. They got what's called early discovery or expedited discovery, which means the SEC can start asking questions now and they have to give responses faster. They can take interrogatories or ask for documents or depose people. And on the 22nd, Mr. Middleton and whoever else acts on behalf of Veritasium, needs to go to court and explain to the court why the order put in shouldn't be made permanent. So if you like to watch interesting court hearings and you happen to be in the Eastern District of New York, this one's probably going to be a humdinger. So now I'm going to pass this back to Gabriel to talk not about enforcement necessarily, but paths forward.
Cool. So as you guys can see, there is a whole lot of trouble you can get into with blockchain technology, and there's some regulatory uncertainty. I don't think most of the people we're talking about, other than the Veritasium guys, maybe were sort of consciously doing wrongdoing, but this is a very new and disruptive technology, and both regulators and innovators are grappling with how it needs to be dealt with under the law. So, practically speaking, what should people do if you're trying to develop this technology, if you're trying to sell a token, if you're trying to otherwise issue a token? How do you do this without ending up like Kick or like Veritasium or one of the others? So, primarily speaking, there are really two paths, right? And one of the things we didn't dwell on, but is sort of implicit in what I've been saying, is if you have a security, the basic rule is that every offer or sale of a security needs to be either registered, right, which means registered with a governmental authority, including the SEC at the federal level, or exempt from registration, which are various technical, rules that allow certain sales not to be required to be registered. For example, if they're only to accredited investors, right? So the two options, broadly speaking, are if it's a security, it's got to be registered or exempt, right? Or it could not be a security, right? So let's talk about the security path, right? So we have something in the U.S. That is a relatively recent addition to the securities laws passed within the last 10 years called the Jobs Act. And the idea behind the Jobs Act was to somewhat simplify and facilitate capital formation for emerging growth companies like startups, right? So it slightly relaxed the rules. It didn't relax them maybe as much as some people would like, but so the two predominant options under this are Regulation A+ and Regulation CF, sometimes known as the crowdfunding exemption. And so what you can do is you can take your token, which may be ultimately designed to be a product, but nevertheless also treat that product as a securities in the sense of complying with applicable securities laws under one of these two frameworks. So Regulation CF is, to be honest, not the most useful of the two we'll be discussing for a few reasons. One, it's limited to about $1 million in proceeds, so that's not a very big capital raise. And moreover, you need to hire lawyers, you need to do filings, you need a crowdfunding portal or a broker-dealer, and all those things, of course, are upfront expenses, so that further cuts into the million. And it turns out not many people use this, as you might expect. The other really big drawback to this is that it's a lot like the private placements, in that the securities are, for practical purposes, locked up for 12 months. So, this is not very good for crypto, right? Imagine if you really wanted to buy your token to actually use it on the network, and you got to wait 12 months to use it because it's also a security, and it's a security that's not freely transferable. That's not very fun. Now, however, there is one company that has decided to use this process to place a token. That is Hawk Networks for its Althea blockchain. And the Althea blockchain is designed to be a peer-to-peer ISP network. So instead of getting your internet from AT&T, the idea is you get it from your neighbor. And indeed, there are some places like Colombia where actually this is being used. But the very interesting thing with this is that these guys actually didn't sell their tokens. It's an existing company. It's already capitalized. They didn't need to do fundraising. They literally just wanted to place the token into the hands of users so that the product can be used. And so that's called an airdrop, right? They basically want to give away the tokens for free. And I think this is revelatory of the SEC's positions and how, in fact, how conservative they are, which is not a judgment, but the SEC takes the position that airdrops of tokens that may be designed to appreciate in value over time, even though the issuer is not directly selling them, not directly benefiting from them, but that nevertheless those are securities, and that there needs to be a registration or exemption for those as well. So for that reason, just to kick off their product and basically give away the tokens for free, these guys probably spent a significant amount of money and went through the Reg CF process, and they're the first to do that. Now the other path, and what I think is the more viable path, and in my speculation, the path that I think the SEC would really like to see most token sales go through, is the Reg A Plus process. The Reg A Plus process allows you to, the Reg A Plus process allows you to sell to anyone, accredited investors, unaccredited investors, and to do so with a fully public offering. And the really nice thing about it is that unlike with that Reg CF or unlike with the private placements, the securities are freely tradable immediately, which makes a huge difference, right? That could actually mean that this is worth it. So for that reason, these are sometimes referred to as mini IPOs. On the downside, however, they do require something similar to the registration process. The issuer has to produce audited financials, not audited to quite the same standard as a fully public company, but still audited. And they need to get that offering qualified by the SEC. So in the case of BlockSec, that's 2 years, right? That's not very fast, but it should get faster over time as the SEC and the public gets more used to this. So there are 2 flavors of this. Bottom line, you can raise up to $50 million, and if you are willing to have some ongoing reporting obligations, you can get blue sky preemption, so you don't have to comply with all the individual state securities laws. And this can be a very good option for selling your tokens that also happen to be securities. On the other hand, there are some questions around exactly how this works, right? Because Bitcoin are not treated like securities, and that means they can trade on Coinbase, they can trade peer-to-peer without people worrying about some issuers' reporting requirements being up to date, without worrying about insider trading liability. If, say, a Bitcoin core developer and you happen to know some security flaw in Bitcoin that's coming up and maybe the price, people don't worry about like insider trading liability the same way they do for public companies. But if the tokens are securities, then it's exactly the same insider trading liability and all the same laws. So this does raise some questions as to practicality. And what are the implications, right? So some of the questions that the SEC asked these issuers, which I don't think have necessarily been answered. The issuer gave its position on it, but the SEC didn't say it necessarily agrees, and it certainly hasn't been decided in court, is, okay, so now you have miners on the blockchain network that are processing securities transactions, and they're getting fees as rewards for that. Does that make them broker-dealers? Traditionally, if I just said that about securities, you would think that they were. BlockSec is saying, no, they're not, and I agree, because the security status or which particular tokens are being transferred in a given block are really kind of irrelevant to the miners, but this has yet to play out in court. Another question, very similar, would be, okay, is some sort of network participant who's tracking where these tokens go, or is the network itself required to be a registered securities transfer agent? Again, they've taken the position that no, but no one really knows this for sure. Now this one's really interesting, and I think this shows what a functionalistic approach the SEC staff is taking in order to try to make this work for tokens, because I do think they really want to be practical and try to give companies a path, is BlockSec said, okay, well, we're going to hold a bunch of these pre-mined tokens, we're going to be selling them over time. Those tokens may become pretty valuable on the secondary market, and in fact it's possible that those tokens will end up comprising more than 40% of our assets, and it's possible that technically, since they're securities, we could be an investment company and we're not registered as an investment company. Is that a problem? So BlockStack says, no, it's not a problem. When we hold the tokens, they're not securities. They only become securities when we issue them. So a priori, if you just kind of thought about that in your head, you would maybe think that the SEC wouldn't be willing to run with that approach, and they haven't sort of totally officially embraced it. But on the other hand, they did qualify the offering. So it seems that they're willing to be flexible, and some of this may require having a less literal view of securities laws, that something is a security or it's not a security. Maybe there are, it's more of a Schrodinger's cat quantum type of thing. Another one is Regulation M, right? So people will be redeeming these tokens, they'll be burning these tokens on the network in order to get various things. At the same time, the network will be issuing the tokens. So that's sort of like an issuer buying and selling securities at the same time, and Regulation M is supposed to regulate that. But again, BlockStack taking the position, not in this case, you need to do it more functionalistically. And probably the most interesting one, I would say, which I forgot to put on here, is what is the status of the security? Is it an equity security or is it a debt security? Because if it's an equity security, that means under 12G of the Exchange Act, that if it's held by more than 5,000 persons or more than 500 unaccredited, then and the company has more than $10 million in assets, that company is required to be a fully Exchange Act reporting company. On the other hand, if it's a debt security, that issue does not exist. So again, there BlockStack is taking the position that it's a debt security, not an equity security, but untested in court, no one really knows if this is true, and again, pretty big consequences if you are required to register as an Exchange Act reporting company and you don't. So there aren't any questions around this path. It's a promising path, and people should pursue it rather than just breaking the law completely. But it's not yet totally crystal clear exactly how it works. So with that being said, Drew will now talk about the other path, which is what happens if your token actually is not a security, and you can get reasonable assurances about that.
Thanks, Gabriel. So he told you about two companies that at great expense went through a process to become actual registered offerings of securities. Here's the other way to do it. You could ask the SEC very nicely to write you a letter that says, if I do the following things, are you going to enforce against me? Think about it like in elementary school. Do you like me? Check yes or no. This is the version of doing that in the securities world. You write a letter and say, I'm planning to do the following things. If I do these things, are you going to enforce against me, yes or no? This is the second group of people that got a no back. This project was called Pocket Full of Quarters. The idea here is that we game online right now. And so somebody wanted to sell instruments that acted like quarters or tokens at the Chuck E. Cheese. You buy them, you use them to play games. So far, so good. And they got a no action letter. They said, based on what you plan to do, the SEC would not enforce if you offered that token. So let's look a little bit under the hood. If you looked at it, you saw this one really wasn't a close call. It didn't really seem like a security because it wasn't marketed that you're going to make any money. It wasn't sold in outsized lots compared to usage. It was restrained so it wouldn't be resold on exchanges. The platform already existed. Buying them wasn't something that you did in the hopes that developers would then make the platform. So what's innovative about this? What's new? Well, it's the first time we've seen expressly that an ERC20 token, which is a token generated using the ERC20 protocol on Ethereum, that it's legal or at least wouldn't be illegal to sell this. And it's a baby step along the way. It's not nearly as interesting in my view as what we saw with the qualification of the Reg A pluses that Gabriel talked about. But what this tells us is that the SEC is willing to look at both paths. You can get something out of them doing no action relief. And I expect that securities lawyers going forward are going to continue to try to push the envelope to see what they can get no action relief from, if only for the fact that it's significantly less expensive to try to get no action relief than it is to try to get an A+ qualified. So now I'm going to shift gears. We're done with securities land for a little bit. We're going to talk about something much more like exciting and bright and cheery, taxes. Okay, show of hands, who hated doing their taxes when they did their crypto? Okay, keep your hands up if you did crypto trades but you didn't bother to report them. We have a room full of smart people. I like it. So long before the Trump administration, we had crypto. And from 15 to 17, people made a ton of money buying and selling crypto on exchanges. But what did this all mean from a tax perspective? Well, in 2014, the IRS gave us guidance and said these things are property. You have a gain or a loss, and you have to pay taxes at either long or short-term rates, depending on how long you held the asset that you sold. This is fairly elementary. And between 13 and 15, 802 American taxpayers paid their taxes on crypto trades. Problem, 14,356 had trades in the aggregate of 20,000 or higher on Coinbase during the same period of time. So there's been a lot of underreporting of taxes. And a lot of folks since then have said to themselves, man, I trade all day, every day. This is awful. I have to do all of these computations. My CPA doesn't know how to do this. I don't know if I'm doing this right. I wonder if there's something else I can do. Well, and everybody looked at this thing called 1031 and said, hey, wait a second. There's this little part of the code that says if I sell like-kind property for other like-kind property under some circumstances, I can defer or pass forward the tax basis, including any gain. So, eureka. I don't have to pay my taxes until I do something later. Whether this existed or not is still unclear, but as of 2018, the tax bill that was passed made clear that 1031 only applied to real estate. Fast forward to this year. House Resolution 3963 would amend Section 1031 of the Internal Revenue Code to expressly say that exchange of virtual currency for virtual currency of like kind is treated the same way as real property. Hooray. Not really. Why not? Well, let's think about why we have 1031 in the first place. It is easy for real estate to get hyper appreciated to the point that nobody would ever sell it because the tax hit would be outrageous. They'd be content to simply collect rents. As a society, we want people to buy and sell real estate. It's how people knock down old buildings and improve real estate. So we put in this exception to incentivize people to trade hyper-appreciated real estate. Show of hands, who thinks the IRS cares whether you have a hyper-appreciated Bitcoin or not? Nobody cares if you made an investment that went up a bunch of money if the policy reason isn't there. No one cares if you sell your hyper-appreciated Bitcoin to somebody else. There isn't any policy reason to do this. The types of things that have been historically included for 1031, besides for real estate, you've got franchise license in aircraft, things that are very expensive and that you want to see them trade. Things that have been traditionally excluded, stocks, bonds, notes, securities, and interest in partnership. Obviously, crypto assets look a lot more like stocks and bonds than aircraft or real estate. Another thing is that 1031 really doesn't fit the way that we use crypto assets. We buy and sell crypto assets on an exchange, and the exchange usually charges us some money, whether it's a percentage of the deal or whether it's a percentage on the withdrawal. And in a 1031, you typically have to use what's called a qualified intermediary. That has to be a party that's arm's length from both of the trading parties. They have to be insured and bonded, and in some states they have to be licensed. So crypto as an asset doesn't really fit. Crypto intermediaries that are used for trading aren't really like qualified intermediaries, and qualified intermediaries, to my knowledge, aren't actively doing their gatekeeping and sort of middle personing function. And of course, even if 1031 did work, it's not like the gains disappear forever. When you eventually cash out that asset, all of the gains for all of the trades that preceded that asset all need to be paid. You're delaying, you're not just disappearing the gains. So for a variety of reasons, to me, it doesn't really make any sense. And these slides that you can't read, they show you something called a Form 8824. This is the form that has to be filled out for each and every like-kind transaction. So the person that day trades Bitcoin that might do a couple hundred trades a day might have to do a couple 100,000 of these forms if they decide that they want to pretend that they did a 1031. You tell me if this is any better or any worse than just calculating them, paying them. It's probably easier just to do the spreadsheet. But I don't know, I'm just the commentator here. My suggestion to anybody who wants to figure out a way to defer or to avoid paying taxes on their gains and losses on trading crypto, ask your legislature to pass a law that says any gains or losses on crypto asset trades should not be considered taxable income. If you can sell that, you'll be a hero. But using 1031, it just doesn't really fit. Now let's shift gears, staying on the money topic, but going to money regulation. I told you at the beginning that FinCEN was one of the first entities to issue regulation about Bitcoin. In 2013, they came out with their guidance. In 2019, they came out with expanded guidance. This is 30 pages long, and I'm gonna hit the highlights for you. They're in summary on this slide. We're gonna talk in a little more depth as follows. They disclosed for the first time concretely that the funds travel rule applies. What this rule requires is that intermediaries that transact value over $3,000 among each other have to transact information along with that value. The information is the name, account number, address, and identity of the transmitter's financial institution, the amount of the transmission, execution date, identity of the financial institution, the recipient's name, address, the account number, and any other specific identifier. Who thinks that their Bitcoin transaction includes all this information? It doesn't. Who thinks that their exchange is routinely sending this information to the other exchange or among parties when they trade? They don't. This is something that does not work on chain the way that chains are built right now. So it's an open question as to how regulated intermediaries are going to comply with this. Let's talk about peer-to-peer. This was something that was sort of under-addressed in the prior guidance. This is the person who maybe goes on local Bitcoins to find somebody else to trade with. Are they required to comply with the BSA to have an anti-money laundering and KYC program? You bet. They say that people who engage in buying and selling of CVCs, convertible virtual currencies, are money transmitters or money service businesses, and they have to comply with all the requirements. The exceptions is for actual people who engage in this infrequently and not for profit or gain. If you ask 100 lawyers what infrequently means, you might get about 109 different explanations. I don't know the answer. Let's talk about wallets. There are a bunch of different types of crypto asset wallets. You have hosted, unhosted, you have those that have multi-sig where you might need another party in order to move assets. And so it was an open question as to whether wallets or wallet providers were regulated. And they came out with 4 criteria. You have to look at who owns the value, where the value is stored, whether the owner interacts directly with the payment system, and whether the person is acting as an intermediary has independent control. Basically, unhosted wallets that the owner controls, probably not required to register. If it's hosted by somebody with control, they probably have to register. Like many things, including securities, fact-sensitive inquiry. We're constantly experimenting with new forms of intermediary. We're constantly trying to find new ways to do this with various conduct with crypto assets. We're a creative bunch, facts and circumstances. Crypto kiosks, crypto ATMs. This is also pretty common sense. If you use the ATM to check your balance of your account held by somebody else, and maybe just to withdraw your own money, that doesn't need its own that doesn't need to register and comply. But if you accept currency from someone to buy and sell or to transfer assets, those ventures need to register with FinCEN and comply with the BSA. This was pretty much the expectation of the industry, and most major ATM companies were complying with this, but it was good to see it written out. dApps. There's decentralized applications. The idea that you can do something with a piece of code that runs independent from a person on some level. This is where this guidance showed quite how much the government has learned and quite how sharp they were going to be about this. They took a position here. They said that software does not have to comply or register. The software is just software. People can make the software that they want. However, if you use software to do a thing that is regulated, where you will be required to register, then you have to register that your use. What does that mean? If I release a piece of code, it's not going to be governed. It's not going to be considered a money service business. You're not going to have to comply with the BSA. If I use that piece of code for money service activity, I need to register. I need to comply. It's the user of the software, not the creator of the software. This is consistent with prior technology agnostic approaches of a variety of different regulators, looking for responsible humans who are making money or are facilitating the conduct rather than those that wrote the code. My view, smart approach. Let's talk about anonymizers. You might have heard them called tumblers. These are systems that put a whole bunch of different transactions together to confuse as to the one-to-one relation or the direct relation between sender and recipient of any given value. Again, software doesn't need to register. People who are using this as a business that are facilitating money transmission need to register. Let's talk about anonymized virtual currencies, your grins and beams and Moneros and Zcashes and all of their different flavors. What about the funds travel rule? How am I supposed to know who is who if I'm using it in a shielded capacity where I may not even be able to tell the public keys? Well, they don't care. You have to comply. So this is going to be a challenge for those anonymized assets. And I'm going to end on, in my view, a high note, which is the admonition that internet casinos also need to comply. Now, obviously, we have gambling of varying legalities around the country. There are plenty of nice casinos you can go to. There are some online casinos, I believe, that are legal in some jurisdictions. But FinCEN has a really interesting definition of internet casinos. They include predictive markets, information markets, decision markets, idea futures, and event derivatives. So to me, that sounds like an Augur and stocks and other similar platforms. And it sort of conflates them with other more traditional regulated gambling and says, if you're not subject to an information reporting and anti-money laundering requirement because you're traditionally regulated like a casino, you're still regulated here. So we're going to leave this on a high note. This is the end of the presentation. Thank you all for hanging in through a hyper-technical discussion of some of our latest goings-on in the crypto world.
Thank you, Drew and Gabe. So we're going to open it up to questions, but first my question, which is, how do you guys see blockchain technology changing the way that lawyers do business?
I'll take a crack at that. So I was like talking to sort of an old school lawyer about this stuff a while ago, and he was asking me about the technology and what I do as a practice, and I think he sort of hit the nail on the head because he sort of said, you know, my whole career, and he was a tech lawyer, I was a tech lawyer in Silicon Valley before I got into this stuff, and I could say all the M&A transactions that I worked on, I didn't really need to care very much about what technology was being sold in the transaction. The deal was the deal. The market trends were the market trends. They were specific to the sector, not a particular technology. In the case of this technology, though, I actually spend like an astonishing amount of time like poring over GitHubs and trying to understand the intricacies and figuring out the right way to draft around it. If you guys like check out a presentation I have on YouTube about smart contracts and how to draft legal contracts that are about smart contracts, I get into a lot of this. But basically, you need to understand the technology deeply, and you need to understand how the transaction, how particular legal concepts are going to be implemented on chain. So to me, that means that lawyers are going to have to become a lot more like developers. I also think, like with all the stuff that you saw here, not to mention the whole world of DeFi. I don't know how many people have heard that term, but it's big on Ethereum right now, and it's basically creating derivatives on Ethereum, different types of securities on Ethereum, but on a decentralized basis. Coders are also going to be more like bankers and more like lawyers. So there's this certain convergence that's naturally occurring in the space, and everyone's going to, the boundaries are becoming more porous. I'm taking Lambda school right now to learn how to code, and I know other lawyers who are working on learning how to code as well. I know coders who are thinking about law school, so it's very much a thing, and it's leading to those changes.
I think the legal world is looking at this with a great deal of curiosity. There's been reports that blockchain lawyers are very coveted, given the amount of attention being given to the industry. I think that within law firms, legal practitioners are trying to innovate and trying to figure out how to use this technology productively. A lot of folks have used this technology to make themselves a lot of money. Given the environment of enforcement and litigation, lawyers are also going to do well for a while. But I think blockchain technology might be useful for things like data collection and litigation especially, that could be very helpful. I think that integration with AI might down the road be useful, but I'm a little bit more bearish on AI than most. But I think Gabriel's points are well taken. Those who are in the market to bring products for sale are having to engage with mechanism design in a way that's really new for lawyers. I don't know if every law firm is going to need to be populated of legal coders, but I'd be surprised if major law firms didn't have some of them.
So attorneys, learn how to code, otherwise you're verifying contracts that you actually aren't reading yourself if you can't read code. So any other questions, you guys?
Hi there. Thank you both for your discussion today. Two questions. In regards to the Kick lawsuit with the SEC, do you anticipate Congress coming out before the courts reach a decision with new law that might, impact the result of that case?
I'll take that. I monitor legislative goings-on pretty regularly. There's been nothing coming out of Congress specifically trying to address this problem. I don't know what's going through the mind of Congress. I wish I did on a number of levels, but there's nothing that I'm aware of seeking at that point.
The blockchain associations. I think there was one bill that's been proposed.
The Token Taxonomy Act?
Yeah, that's right, the Token Taxonomy Act, and that would, I don't think it's going to get passed, but the idea behind it was to carve out certain types of tokens from the definition of the 33 Act. I don't think that would apply retrospectively necessarily, and I don't think it's going to get passed, and I also think it's just dumb. But for what it's worth, that has been proposed.
And the other question, you kind of hit it on it before. What use cases, I don't have money. What use cases do you guys are seeing now? I know you guys talked about the future, what it could be used for, but do you know of any use cases that are actually companies using cryptocurrencies now, currently?
Well, I don't know about companies, but DeFi, I mean, all the use cases are speculative for financial speculation. I think the latest evolution of that is DeFi on Ethereum, where people are, for instance, using MakerDAO to take out collateralized debt positions. Those can also serve as a form of leverage trading on the underlying collateral. There are also interesting things like compound finance that are essentially paying interest on crypto, but on a decentralized basis. So that's a form of use case, but obviously it's still financial based.
And in terms of I'll let you answer first, Drew, go ahead.
Thank you. There are companies that are looking at blockchain more than necessarily the financial instruments that we've been talking about. There are shipping consortia, there are provenance, there are food tracking projects, there are identity plays. There are a number of places where there's experiments going on. I don't know if any of these are going to take over the world. I'm kind of the view that blockchain wins when it is so fundamental to the way that we do business that nobody markets that their product uses the blockchain. It's just in there doing its job. No, you very rarely buy a piece of software now that says, now including TCP/IP. It just, it's online, it works there. So my view is, depending on what you think a blockchain is or isn't, almost every software right now uses a database. the relevant industry doesn't know what a blockchain is yet. We all argue in our little tribes that our version of a blockchain is more real than the other one. It's a data system. So is there going to be some implementation that's more valuable in one context or another? Sure. In the future, maybe does Oracle decide that they're going to use a decentralized database model instead of a cloud model? Maybe. I don't know. But I think you're going to start to see aspects derived from this technology become more insidious, just kind of show up everywhere.
Some use cases as well is right now IBM has this, and Walmart have the IBM Food Trust. So I think if by the end of 2020, you are a partner with Walmart and you provide them with, I think, greens, leafy greens, you have to be on the IBM Food Trust blockchain, otherwise they're not going to do business with you anymore. Now in reality, in terms of blockchain, the one that has a real use case, it's Bitcoin, right? So for example, in Argentina, this happened, I don't know, maybe 3 weeks ago, where the Argentinian peso dropped 50% in one day. And the price of Bitcoin in that country, you could have bought it 3 times the price here in the United States, because what it does is it provides an asset that is less volatile than these traditional currencies, these fiat currencies of governments. So there are real world use cases, like for example, right now in Miami, there's a public-private partnership going on with the Port of Miami, the Miami Airport, and the Beacon Council to make our ports smart cities, right? So if you want to learn more about that, we can talk about it, but definitely there are real use cases that are happening.
On the use case front, I also wanted to add remittances. Bitcoin is still the cheapest way to move millions of dollars cross borders instantly. So, but I did have a question. So I'm actually a CPA. I specialize in working on blockchain, and great job on the 1031 thing, nailed it. So one thing that we deal with and have to talk to clients a lot is around hard forks. And so I wanted to get your ideas, because hard forks is a very crypto native thing. What are your thoughts around hard forks from like a security standpoint, right? So let's say you have a security, you've gone through your whole issuance, and then someone hard forks your network, or even if you want to go and talk about tax implications of it, but like, what are your thoughts on hard forks and the legal ramifications of that?
So very quickly, a hard fork is when you take an existing crypto network, change something about it so that some of the miners are compatible with the old network and some are not, and the system continues to operate now in 2 different states, 2 different paths. The first question that I'll address, because I have a feeling Gabe's going to want to talk about the security side, I'll talk about the tax side. Let's say you bought a Bitcoin for $1 in 2010. If you're still holding that original Bitcoin, you technically have an entitlement to claim, I believe, 68 different forks of Bitcoin. From a tax standpoint, if you sold that $1 Bitcoin for $10, you probably have a $9 gain. However, if you decide to split that Bitcoin into all 68 of its variants, you now have 68 discrete assets, and you have 1 token or 1 Bitcoin that you bought that had a $1 basis. Let's suppose you sold all 68 of those assets, and you got $68. How much of a gain did you have? Do each of those assets start with a $1 basis? Can you only allocate some of your basis to some of these? Can you allocate over and over? It's not clear. The AICPA, the American Institute of CPAs, has written 2 letters to Congress, or to the IRS, asking them to give guidance on a host of issues, including system forks. In my view, the thing that makes sense is if you have an instrument that has a basis, if you want, you can allocate the basis, but you can't double allocate. If you have $1 to spread between all 68, you're going to have, you give half to one, you only have half for the other 67. That's how it should be. Right now, there really isn't any clarity.
Yeah, so on the securities side, I think you have to make a distinction, right? On the one hand, there are tokens like those block stack tokens that are ultimately designed to function as products. It's just, unfortunately, because they're also sold for money, they happen to also be securities. And then there are ones that are sort of like tokenized securities, right? Like stock represented by a token, where you're not also using your stock as a software license, right? So it differs in those 2 cases. In the case of like tokenized stock, you never want 2 of those, right? Because the certificate of incorporation it means something legally. It means a share of equity in a corporation. which is an off-chain thing, and you don't want to like suddenly dilute everyone. That'd be like doing a stock split or something. Like a hard fork can't be a stock split. That would be a terrible result. So that means if you're representing your stock via tokens on a public blockchain that might fork, you're going to need to have some fork handling rules in your bylaws and or certificate of incorporation that say what happens in the event of a pending, threatened, or actual fork. And basically it's going to mean that for those types of tokens, those are never going to be completely unpermissioned assets. The issuer is going to need to retain the ability to sort of freeze those if something like that happens, pick a particular side of the chain, and only have one version. This also comes up in contracting, right? Because if you have a contract that says, hey, I'm going to sell you Mar-a-Lago for 100 BTC, what does BTC mean? And what happens if during the term of that contract, before the transaction is closed, BTC forks? So you should also have a rule in that contract for what you do in that case. One thing you could do is you could just say, you know what, I really like the Bitcoin Core client. I trust the people who run that client. Whatever version of Bitcoin is recognized as true Bitcoin by the Bitcoin Core client, that's BTC. There are other possible approaches as well, such as stopping and arbitrating, etc. In the case of something like Bitcoin or Blockstack tokens, when that forks, it's not as big a deal because those things don't really mean something legally. They don't represent something else. So now you just have two different blockchains, you have two different tokens that crypto natively do something within some software framework, but it's not as big a deal. There are tax effects, etc. But in my mind, that's not as complicated a scenario.
Thank you. We also have one question from one of our online members. How does taxonomy in Florida affect money transmitters laws, if at all?
Can you repeat it? I'm sorry.
How does taxonomy in Florida affect money transmitter laws, if at all?
How does the taxonomy in Florida affect? I think.
Probably they meant the Token Taxonomy Act or taxonomy in Florida. I'm not sure.
Sure. So the Token Taxonomy Act is a pending federal bill. It would not have any effect on the laws of Florida, with the exception of the fact that there's an attempt to preempt state law with respect to crypto assets except for fraud. There are a number of folks that question the constitutionality of that provision, whether it would be enforceable or not. We have a separation of powers in this country. The fiction is that the power comes from the people to the states, and then the states give a limited delegation of power to the federal government. So the federal government has less power than the states, except for things that are specifically enumerated to be federal powers. There are many things that are both state and federal. Making courts, creating roads, passing taxes. Those are called concurrent powers. The attempt by a sort of, in my view, clumsily written statute, which the Token Taxonomy Act is, to fully preempt every part of regulation of a broad, ill-described set of digital assets, including things like taxation, securities, and what have you, things that are traditionally concurrent, doesn't seem to be a winner in my view. Florida has enough confusion about how it handles these assets. This introduction of this federal statute is just going to make things more complicated. I share Gabriel's view that I don't think it's going to pass, but neither Gabriel nor I have votes in Congress, so we're just two people's opinion up here.
There's a difference between federal and state laws, and I mean, people normally have their preference on which laws are more important, but federal laws sometimes are just, they don't make sense for every state. So, questions, guys? Wow, there's a lot. All right, over there in the gray, if you want to stand up.
Hey guys, so awesome job, super informative. I'm a litigator, and one thing I thought you guys did really well was break out some pragmatics of how this stuff might affect a company. And I think like your second or third case example, you talked about a TRO, temporary restraining order, being put into place, and the court appointing an intermediary.
So if a court says you need to stop what you're doing, I feel like a lot of companies won't necessarily have a big red button that says stop. And then if a court says we're going to put in an intermediary that has to step in and run the show, how does that pragmatically play out? How did that play out there?
So the intermediary in the Veritasium matter is basically like a receiver pendant lite, which I'm probably saying wrong, but it's like a baby receiver. The direction was that the defendant, the one that's subject to the TRO, was going to give the SEC the name of the party they wanted to act as the intermediary. They were going to give all of their crypto assets to that intermediary, and there was already disclosures attached to the TRO of bank accounts that would be subject to the freeze order. This is a traditional freeze order like we see in other actions brought by regulators. The crypto side of it required the defendant to disclose their addresses, to identify the one person that they want to handle those assets during the time for which the order is in effect, requires them to make that transfer within X amount of time to cooperate. And we're going to see in 2 or 3 days whether that injunction with the appointment of that basically receiver light is going to continue. Any other questions here?
Quick question. I'm a developer. I'm working on a project. So my question is, if I want to give away Bitcoin for free as a reward, do I have to comply with KYC rules or regulation?
I'm going to hand it back to you.
So the first thing they teach you at law school is it depends. And it's cute to say that, but it's also true. There was a case, I believe, called Tomahawk, right? Where a gentleman was settled with the SEC. There was a cease and desist order. In Tomahawk, there was a giveaway of assets in exchange for some other work. The gentleman was selling Tom coins. He wanted to get them all out there so that he would have sufficient distribution to do something else with those assets. And the court ruled that even though there wasn't a sale, the promotion of that, the promotions that people were doing in exchange for the assets was conferring value on the issuer, and it was considered the contribution of value prong for the Howey test. So if you're literally passing out dollar bills outside, maybe that's one thing. If you're giving people Bitcoin so that they do something else that drives value to you, you might be looked at like the person in Tomahawk. I say it because it's sort of cute, but it's also true. It really does depend.
Well, but
So in Tomahawk, though, they were issuing their own tokens, so conceivably we're acting as like a securities issuer, right? So I mean, I think in the case of Bitcoin, it's reasonably well established that it's not a security. No one's viewing it as a security. There may be other issues there, like money transmitted, which is why I handed it to you. But obviously you always want to think about these things, and just cryptocurrency in general always has like extra skepticism / danger associated with it. In general, I would be surprised if there's an issue if you're truly just giving Bitcoin away as an incentive. You may incur gift tax, right? There may be other issues there, but I don't think there's a securities law issue as such.
Again, if you're doing it in conjunction with something else, it might look like a security. If you're giving things away, you might have gift tax, you might be viewed as a money transmitter. Get a lawyer. Any other questions?
How are you doing, guys? Great presentation, by the way. I was just wondering, where do you see the industry going? There was a lot of ICOs last year. US was a major ICO. But I see that it's kind of like we're picking up on STO, security token offering. So I'm kind of seeing, I kind of see where the industry is going, and do you guys think it's going to change to STOs?
Right now, for all intents and purposes, the old school ICO, which was the sale of an asset without compliance, is dead as a doornail. In the United States, if you want to sell tokens, if you don't get a no action letter and you don't use a registration exemption or publicly register, you're probably going to be enforced against. Abroad, you've got a different world. There are some jurisdictions like Singapore and Switzerland that recognize totally different assets than we do here. There are some jurisdictions that are being treated like the Wild Wild West. Domestically, we're looking at a world where you're registered, you're exempted, or you're probably not doing it.
Awesome, give it up for our Amazing attorneys. Good copy, guys. Okay, so just to close it out, I want to invite you guys to some things. But first things first, our buddy Drew Hinkes here. So you saw those NFTs sliding across the front. I hope you picked yours up. They are collectibles like crypto kitties. But we have a special NFT for 10 guests, which is 15 minutes of time with Drew. So if you're interested in getting one of these NFTs, Drew has them to give out. And I have a couple too, so come ask for 15 minutes. Drew is also going to be doing office hours here. So please make sure you are to our Telegram, you're subscribed to our mailing list, or you're at least part of the meetup group so we can tell you guys what's going on. The next upcoming things. So on the 22nd, so wait, first of all, who here has heard of Lolly? Yes, I have some Bitcoiners in the house. So basically Lolly is a service that when you buy things online, they give you Bitcoin back, right? And so it's kind of like a plugin you can put into your browser and then you get Bitcoin back. And they're globally effective, but we are having a party on the 22nd at the Langford, at Sky Bar on the Langford. If you're part of the chat room, you'll learn about it, but it's very close by, that'll be awesome. And the next thing is, how many of you guys have been to the Faena Forum before? Nice, it's a very nice venue, very new, on Miami Beach, probably one of the top party spots in the city. And we are having a party there. My computer's not working. We're having a party there. And you guys know who DJ Irie is? DJ Irie, he's the DJ for the Miami Heat, and he is our DJ for this event. We have Nick Spanos from Baking on Bitcoin, and hopefully a lot of other local celebrities coming out to this event. It is on September 13th, so save the date. And, oh, there we go. Okay, also another question. Who has an iPhone? Half the room. Did you guys know that if you pull out your camera and you go like this, a link will pop up. Like, I mean, it surprises me how many people don't know this, but if you have an iPhone, you just pull up your camera, scan the link, and then it just opens it up. Now, if you have an Android, open up a QR code reader and download it. But if you have an iPhone, all you do is like scan a QR code, so it works everywhere. On the way out, you're gonna see all these different QR codes to get you connected with us. And just scan it, guys, get in touch, super easy. Technology, right? Technology. And then last thing, before we, sorry? Yeah, free crypto. Oh yeah, I forgot to tell you, if you come to that party at Faena Forum, it's eToro. eToro is a social trading platform. If you fund your account, you get $50 in your account when you come to this very sick party with free food and free drinks. Okay, so 2 more things. Our next Crypto Mondays. So we do these every 2 weeks. The next 2 weeks is Labor Day, so we're gonna give everybody a break. But the 2 weeks after that, we have a very important guest. It's gonna be a different type of format. It's gonna be an open forum to where we want you to come to us with, hey, this is what we would like written in the Florida legislature. So we'll release who's talking, but it's a very important, influential person. And when you come, make sure you think like, okay, this is what I would like to be like, because we have this Florida blockchain working group, blah, 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 blah. It's really interesting, but I'll get off the mic because last things last, who is coming with us to the after party at Lost Boy? Cool, I'm sure more of you are, but if you are and you don't have one of these green bands, please come find myself or Maria or Nick because you get 50% off drinks because we're really trying to change Flagler Street, guys. This is all about Miami. This is all about bringing growth, jobs, development to this city, particularly this part of the city. So we work a lot with some partners here to get that happening, and Lost Boy is one of them. And last but not least, follow us on Twitter at BlockchainMIA, and we're gonna be releasing surveys to make sure that the content we share is the content that you wanna hear. So thank you so much, you guys, and enjoy.